I'd like to introduce to you Fred Streiman, Managing Partner of Dale Streiman & Kerrs. Fred, tell us a little bit about your background and experience.
I've been a lawyer for almost 30 years. I've practiced my entire career in Brampton. I've lived in Brampton for almost my entire adult life. I'm very active in the community. I'm the treasurer of my synagogue. Been involved in fundraising for many charities. It's something that I really enjoy, and Brampton's my home. I've watched it grow from a little village, not a little village, but a small city into the giant city that it's become. I have almost from the outset, even all the way back at law school, family law has always been the area of law that I was most interested in. I participated in the law clinic at law school, and we're helping people, actually helping potential clients when I was still in third year law school. It's always been the area of law that I've always come back to. It's been the center of what I've done, and I really enjoy it the most, along with wills and estates, which in a lot of ways is a very close adjunct to family law.
How does the Family Law Department tie in or complement the Real Estate Department here at Dale Streiman & Kerrs?
Generally in two different ways. It's extremely common for a real estate client to come to DSK, and the real estate lawyer, in speaking with them, will realize, wait a minute, there's some very serious family law repercussions, such as people who are going to be buying a property together, they're not married, and they haven't thought about, well, what might happen if one of us dies or if we go our separate ways. Particularly crucial area would be if one person is putting in the vast majority of the money to buy a house, yet title is going in both of their names. So that's one area. Also, our real estate clients will become aware of the fact that there's somebody else that's immediately related to them or that they know of that needs some help with a family law problem. Alternatively, the family law department refers people onto the real estate department. It's not uncommon for one of my files to need the assistance of the real estate department. That frequently happens when you'll have spouses that are separating and one is buying out the other's interest, so that needs to be attended to.
Can you tell me a few instances where family law is really required in a real estate transaction?
Well, I think it's extremely important, just going back to that example that I talked about a moment ago, where two people, often who are not married, sometimes it might be a second or third marriage for them or a second relationship for them. Everybody's love struck and thinks that things are going to turn out right, and I think we all hope that that's what's going to happen. But unfortunately, we live in a real world. So if one spouse or one partner is putting in $100,000, $200,000, $300,000 from a settlement or from some other one of their assets, and they're about to move in and buy a house with someone else, but because love is blossoming, etc., you know what, let's put the house in both names. Well, bells start ringing for the real estate lawyer. Wait a minute, you're not thinking about protecting yourself, but it's the lawyer's job to at least warn you. You should be doing something about that. And the best way to do that is by way of a cohabitation agreement. And that's something that Dale Streiman & Kerrs can help you with.
What are the benefits of being a full-service law firm?
In efficiency, in the sense of the lawyer's time, the ability to have questions bounce back and forth and get an expert opinion right away. It's actually cheaper for our clients. You don't have to go farm a file out to yet another law firm. It doesn't have to get transferred. Someone else doesn't have to learn the file. Everybody knows, you know, the having it under one roof makes it more efficient. Things happen faster, and speed almost always equates to saving money.
What are the most common family law issues raised by a real estate transaction?
It's generally fact-driven, and the factual situations that almost always ring bells are a second marriage, and then you really need to think about what you want to do. And another really sort of trigger point often are people who are not married and are buying a house together. Those are two situations in which family law rules, family law considerations need to be addressed, and almost always the underlying issue is, or the underlying question rather, is what happens if something goes wrong? And that's a difficult question to answer at the beginning, but it's one that if you don't do, and life is life and problems arise, and if you don't deal with it relatively simply and easily at the beginning, it'll come back to bite you. And it'll be a horrible conflict for everybody, expensive, and not just monetarily, but also emotionally.
What are the disadvantages or problems of a parent putting the property in the name of a child or beneficiary before their death?
So I'll give an example. Someone's husband has died, and the woman is now 65 years old. The only age asset that she's got is the family home. She's living there, she has 3 children, and she's getting along fine with them. And she decides, you know what, I'm going to avoid the necessity of doing a will. I'm going to avoid probate fees. I'm going to avoid lawyers' fees. I'm just going to transfer my house from just my name into that of myself and my 3 children. Well, let's go over what the advantages are of that. It will indeed save probate fees. It will indeed save the eventual lawyer's fees with respect to the estate. That will happen, and it'll happen instantaneously upon the death of the mother. What's wrong with that? Well, there's a lot of things that can go wrong. One is, what happens if one person dies out of order? One's assuming that mom's going to die first, and then the kids will be left over. Another very serious problem is, what if there's a falling out between a child and a parent, in our example? Very serious issues, very, very serious problems. Once you transfer title out of your name entirely, the mother has lost control of that property. The angry child, in our example, could force through the court to have that home sold and the proceeds divided up. Another problem is, what if everything goes great between mother and children, but one of the children separates from their spouse? That estranged spouse now has a shot at his or her mother-in-law. Another problem is you're ignoring the fact of there's only one principal residence with a capital gains exemption. So if the son, for example, has a house of his own, but now owns 1/3 of mom's house, you can't have 2 capital gains exemptions for a principal residence. So if mommy's house goes up in value, there will be capital gains on the child's share. Another problem is, well, what if everything's fine, kids and the family, everyone gets along just fine. What if one of the children gets sued and gets sued successfully? Well, the person who sues successfully can now look to the interest in the mother's home to collect. There's some very, very serious problems. Generally speaking, we believe that in most circumstances the problems outweigh the advantages. But it's something that needs to be looked at on a case-by-case basis.
What about a situation where a couple is separating and selling the matrimonial home, and they've come to an agreement informally without legal advice, and they come to the real estate lawyer to complete the sale transaction? What about that situation?
Well, that's a problem, and the problem is the following. If you do anything as a result of a matrimonial split, and you have an agreement with your spouse and everything is just fine and this is what we're going to do, but if you don't formalize it, if you don't turn it into a formal agreement done with a lawyer, or alternatively it turns into a court order, then you haven't accomplished anything aside simply relying upon the good wishes and graces of the other person. If that other person decides to change their mind or decide that they didn't get a fair deal, you may think that the matter's over, but unless it's been formalized and formal releases have been exchanged, nothing's been accomplished. You've just sort of shifted the piles around, but you've not dealt with the rights that each of you have under the terms of the Family Law Act.